Welcome back, everybody, to our studies in the criminal law. This lesson, we're carrying on looking at the idea of various different defences, namely the capacity defences, focusing instead on the issue of insanity. We're going to cover the basics of this idea in this lesson, and it's relatively simple, the defence of insanity. It is not that difficult to understand. We will get to some of the more complicated ones as we go on. So when we start looking at intoxication, whether that be voluntary or involuntary, when we start looking at duress, and when we start looking at self-defense, these are a little bit more complicated. But for the most part, things like insanity, things like age, things like automatism are all defenses which are basic and relatively easy to understand. So the previous lesson obviously talked about the concept of age being a defense, a capacity defense, namely that anybody under the age of 10 years old cannot have any kind of criminal liability. This lesson is going to talk about how criminal liability may be negated through the defense of insanity, whether or not an individual who is deemed and rendered to be insane can actually avoid and escape a certain amount of criminal liability. Now remember that when we are doing criminal law, we are thinking about the key components of criminal liability. It is almost like an equation that we build together, and the key components have to be satisfied in order for criminal liability to be shown. So you have to firstly show to a standard which a jury would be satisfied with that there is the relevant actus reus, the relevant acts themselves, that they are done in conjunction with the prerequisite mens rea, the mental state. For the most part, of course, there's the exception of strict liability, which is a little bit different. And then you have to also be able to rebut or to essentially negate any defense which could be levied in relation to these acts and the mental state therein. And so with all those things, with an actus reus plus a mens rea minus criminal defense, we get to and we arrive at the idea of criminal liability. So the defense of insanity is one such defense that we could actually levy in order to show that the defendant did not have the capacity to act in the way that they are alleged to have acted. It's relatively easy to understand. It requires a number of different elements. The leading case for the defense of insanity is that of the McNaughton's case from 1843. And so basically in covering and taking an overview of the defense of insanity, what I'm going to do is just go through the McNaughton case, and I'm going to look at the facts of this case. I will look at the judgment which is rendered at the end of this case, and I'll talk about the key principles that are established therein. Notice here that this is a case from 1843, so the law has been relatively settled. It's not been that controversial, it's not been that turbulent over the years. There have obviously been slight changes here and there, and obviously the growth of mental health litigation and mental health law, as well as the sort of growing perception of mental health in society, has obviously made slight differences here and there, but for the most part, it is relatively stable in terms of the law that has been applied here. So the McNaughton's case, or McNaughton's case from 1843. This was a case involving the killing of the secretary of Sir Robert Peel, who was somebody by the name of Edward Drummond. So Robert Peel, of course, was originally the Home Secretary, and I believe he became Prime Minister at some point. I'm not sure. I don't know my 1800s Victorian England history as well as I would like, but it's somewhere along that line. Ultimately, McNaughton had intended to actually kill Sir Robert Peel himself, but had mistakenly attacked his secretary, Edward Drummond, and had killed him instead. So, a mistaken identity, but still a killing nonetheless. The case for insanity and the defence of insanity was brought up, and the House of Lords thought of and started to discuss the various different requirements that would be necessary for showing such a kind of defence. Ultimately, in order for a person to be found not guilty of an offence by way of insanity, there must be two general requirements that are satisfied. This is what the McNaughton's case establishes. Firstly, there must be a defect of reason which is caused by a disease of the mind that the defendant did not know the quality and nature of the act. Secondly, a defect of reason has to be caused by a disease of the mind where the defendant did not know the nature of the act, did know the nature of the act, but did not know that the act was wrong. So generally, two requirements. Of course, they're not necessarily they are for the most part mutually exclusive in terms of how they operate. You either are somebody who has a defect of reason, which is caused by a disease of the mind, quote unquote, and you did not know the nature and quality of the act that you are doing. You did not know what the act was, or the nature of the act, or the type of act that you were performing. Or you have a defective reason which is caused by a quote-unquote disease of the mind where you do know what you're doing, but you do not think that what you are doing is wrong. You do not have the sort of mental state to consider the immorality or the illegality or the criminality of the conduct that you are engaging in. And it says here, quote, "The jury should be directed that every man is presumed to be sane until the contrary be proved to their satisfaction, and that to establish a defence on the ground of insanity, it must be clearly proved that at the time of committing the act, the party accused was labouring under such a defect of reason from a disease of the mind as not to know the nature and quality of the act he was doing, or if he did know, that he did not know that what he was doing was wrong." So the latter part of this paragraph gives us the two requirements, or the requirements that are the alternative requirements that you need in order to show that there is a valid defense of insanity here. But the first part is also important, okay? This part is something more of a procedural trial basis and almost an evidentiary point that is made. Because it is suggesting here that the jury should be directed that there is a presumption of sanity. A presumption of sanity which is then up to the defense to rebut. They must prove to their satisfaction that the individual is not sane, okay? So that's the thing that should be noted here. There is not a presumption of insanity and then it's up to the prosecution to show that he was sane. You have to presume that everybody is sane, and that the presumption of sanity exists, and then it is up to the defense to show otherwise, okay? And then it must be shown that this was at the time of committing the act. So remember, you can't be completely sane, commit the act, and then go insane, and then claim criminal liability, or claim criminal insanity as a defense. Okay, because obviously there has to be a coincidence of your labouring under a defective reason, such as from a disease of mind, at the time at which you are committing the offence that you are on trial for. And then, obviously, the disease of the mind is causing a defective reason, such that you either do not know the nature and quality of the act, or that if you do not know that what you are doing and what you are performing is wrong, immoral, illegal, etc., etc., etc. This lesson will see the continuation of our studies in the area of defences within the criminal law, namely capacity defences, and more specifically the defense of insanity. The previous lesson spent a little bit of time talking about the defense of insanity, talking about the McNaughton rules, the basic McNaughton principle, and this lesson is going to unpack some of the key elements of this before we start to look at some other capacity defenses such as intoxication, as well as automatism, and then get to looking at some other defenses, such as the necessity defenses, things like self-defense, as well as things like duress. So, as I mentioned, the previous lesson introduced the subject of insanity as a defense in the criminal law, and this lesson is going to look at one of the key components of the defense of insanity, this being the requirement that in order for an individual to satisfy the defense of insanity, there must be a defect of reason in doing so. So the defect of reason requirement is a concept that really is to be shown on the part of the defendant that there was something which had deprived them of their ability to make a sound and reasoned judgment in the conduct which then leads to criminal liability. And really, the thing that deprives them, of course, is something like a disease of the mind, which we'll get to in the next lesson. So there are two conceptions that we noted from the McNaughton requirement. The first being that there has to be a defect of reason, and that this defect of reason is caused. It is caused by some disease of the mind, some kind of recognized condition that would therefore relate to and conclude a defense of insanity. So let's address this first question, and I want to draw your attention to the case of Crown versus Clark from 1972, and this gives us a better indication as to what we mean by the defect of reason, and to what extent and what are the requirements that are needed to show a defect of reason. Remember, this is a presumption that is placed onto the defendant. They have to show that they had a defect of reason that was caused by a disease of the mind in order for them to satisfy liability. There is not a presumption of insanity that the prosecution has to then disprove. So this case, as I've just mentioned, is a useful authority on the subject of the idea of the defense of insanity, specifically the defect of reason. Within this sort of broader conceptualization of insanity as a defense. It is essentially a case which shows that for a defective reason to be present in the sort of psyche of a defendant, it requires more than just the mere momentary loss of judgment or lapse in judgment or loss of concentration. It cannot be the case that a defective reason is satisfied by extension to or by reference of the fact that they have a mere momentary loss in their concentration or their mere momentary loss of judgment that gives rise to them acting in a way which is criminal. So the defendant itself, the defendant themselves, sorry, let's not dehumanize these individuals. The defendant themselves had been diagnosed with depression. Now, this could theoretically satisfy this idea of the disease of the mind, theoretically, okay? So it might satisfy the secondary requirement of the McNaughton test, but the question that this case raised was whether or not it satisfied the first requirement. One of the symptoms of the depression that was being exhibited by this defendant was that she would often lose concentration and they would often act in a way that was akin to a certain degree of absent-mindedness. So they were sort of lost with the fairies, as some might say, when they were going about their day-to-day business as a result of the depression. Now, the events that lead to her committing some act of criminal liability is when she had taken items out of a supermarket without paying for them, and she concludes, or at least she argues or tries to present the argument, that the reason why that she went and she didn't pay for these items, she just walked out of the supermarket, is because of this absent-mindedness, this lapse in concentration that would ultimately lead to her committing this criminal act, of course, the act of theft. At the trial level, what the judge did was make a ruling on the basis of rendering the defendant insane for the purposes of the defense. Rather than having the label attached, the defendant decided to plead guilty on the charges. So this sort of defense of insanity was sort of thrown out, at least at trial, or at least was disregarded because of the label that was attached to the defense of insanity. For a lot of defendants, as I've mentioned in previous lessons, being rendered insane is not a particularly fun thing to have concluded. It could lead potentially to institutionalization, depending on how severe the potential defect of reason may have been, which could, in a lot of circumstances, in quite a few circumstances, result in a situation that is substantially worse than a mere prison sentence or a mere fine or community service or whatever it is that is attached to this guilty plea. And so, as a result of which, owing to the stigma, and especially the fact that there was even more of a stigma back in 1972, when mental health wasn't really the kind of studied and accepted part of society that it is to this day. Even to this day, there's quite a lot of prejudice when it comes to mental health conditions. The defendant decided that she would plead guilty on the charges rather than face a potential insanity defense. The Court of Appeal held that in order for there to be a successful defense of insanity, she would have to show that it was more than just a momentary lapse in judgment that resulted from this disease of the mind. And so the acts that had been performed by the defendant and the argument of a defect of reason that may have been presented was rejected by the Court of Appeal anyway. And the Court of Appeal here is talking more broadly about the defense of insanity and the conditions as well as the requirements for showing a defense of insanity, rather than necessarily striking down what she had argued for. Because again, as we mentioned, she would rather have pled guilty than for the defense of insanity to have actually run its course. It was held as well that because the defendant had retained her ordinary powers of reason, the defense of insanity could not have been valid. So, and also, since the defendant pleaded guilty on the basis of the judge's ruling on insanity, and because it was not a valid ruling, her conviction was actually ultimately quashed, which I'm sure is good for her. Ultimately, then, it shows that in order for you to actually use the defense of insanity in cases like this, you would have to show a little bit more than just being absent-minded as a result of some depression or some lack of concentration, because a momentary lapse in judgment does not constitute the kind of defect of reason that is satisfied by the M'Naughton test, the M'Naughton rules. And so, as a result of this, you would have to consider, therefore, that cases such as this would not constitute a valid defense in terms of, or at least would not constitute satisfying the valid defense of insanity. Still, it was probably a good thing that her conviction was ultimately quashed, because even though she could not rely on the defense of insanity, it, by all accounts and by all intents and purposes, seemed to have been the case that it was this lack of concentration that brought about her decision to, or her lack of decision, which then led to her taking those items out of the supermarket rather than a real guilty mind. So that's still a good thing, nevertheless, but it's interesting that this shows that there is quite a high standard, quite a high requirement for there to be a successful defense of insanity. In the previous lesson, what we did was spend a bit of time talking about the first key component for the defense of insanity, as cited by, obviously, the M'Naughton case. We noted that in the M'Naughton case, or essentially the basic two requirements that are necessary for showing the defense of insanity are, on the one hand, that there was the act that was committed was done as the result of some defective reason, and then secondly, this defective reason was the result of a disease of the mind. Now, we noted in the previous lesson, and we spent some time in the previous lesson focusing on the first of those categories, this idea of a defect of reason, and we cited the case of Crown and Clark, which was a case where essentially an individual had taken some items off of a supermarket shelf and they'd left without paying for it, and their argument, or at least an argument that was presented, was that she had depression, and this depression, one of the symptoms of this depression was this idea of just a loss of concentration and absent-mindedness about her person. But the Court of Appeal concluded that such a defect of reason would need to be a much higher standard. It needs to reach a higher level than as defined there in that case. This lesson is going to talk about the second of these characteristics, the second of these issues. This is the final lesson on the subject of insanity, and we will examine the requirements that the defect of reason, which we noted is a higher standard than was cited in the case of Clark, Crown and Clark, needed to be caused by a disease of the mind. Okay. So disease of the mind and the concept of the impairment or the defect of reason being caused by a disease of the mind is the most substantive element of the defense of the insanity defense. Generally speaking, when we think about unpacking each of these things, unpacking each of these components, the concept of mind is taken to have something of its ordinary meaning within English, within the ordinary definition of English. Okay, so it includes things like your mental faculties, your concept of memory, your concept of understanding, all of these different kinds of things. We don't become philosophers of mind and start unpacking and analyzing all the various different elements of consciousness and mental states and brain states and all these different things to ascertain whether or not the disease is of, quote, the mind. We take it as a sort of broad, ordinary English meaning that you would find in a dictionary. The idea of your mental faculties, your concentration, your memory, your whether or not you are truly, let's say, in the room, if you will, if you're not absent-minded, all these different things as well. So the definition of disease of the mind, however, comes from the case of Sullivan from 1984. Now, the Sullivan case is a case which involved a man who had had an epileptic fit, and as the result of the fit, he had attacked one of his friends. So moving about, and he went about and attacked one of his friends. The defendant would plead guilty and be convicted for a certain non-fatal offence, so assault or battery or ABH, etc., etc. He would appeal that the trial judge ought to have directed the jury towards the defence of automatism. Now, automatism is a defense that we've sort of made mention of in previous videos, but we haven't actually got into in any detail yet because we're going to do that in future lessons. But essentially, automatism is this idea of the body moving and the body acting without the mind itself, okay? And there are some arguments that have been presented in the past suggesting that things like epileptic fits or people who go into sort of hyperglycemic shock and all these different things may experience a type of automatism where they are actually not mentally in control of their body, and so as a result of which it cannot be said that they actually have the ability to commit an offence. Other examples of automatism include things like muscle spasms. I'm sat next to somebody on a train and I have muscle spasms and I spasm and my arm flicks out, okay, without my brain telling it to do so, and it hits somebody in the face. I cannot be then held liable for assault or battery or whatever as a result of that, because of course it wasn't me really that did that. You sort of define personhood in the criminal law as your sort of mental state, your sort of the brain state, the things that make you you. And so as a result of which, if you have a muscle spasm or you have some kind of epileptic fit, it seems to be the case that your body is acting in a way that your mind is not controlling. And so as a result of which, there is this defense of automatism. This was rejected, however, the appeal that should be made about the defence of automatism. It was rejected by the House of Lords, and as a result of which, the conviction of the individual who hit his friend was upheld. And it was in the deliberations, and it was in the judgment finally that was handed down by the House of Lords, that Lord Diplock give us something of a definition of disease of the mind for the purposes of the insanity defence. So in this case, insanity doesn't play that much of a role, at least in terms of its application or necessarily some of the ideas therein, because the jury, or at least the defendant and the defendant's counsel, wanted the jury to be directed towards the defence of automatism. And to discuss the idea of automatism. But instead, what Lord Diplock does is talk about the idea of insanity, and specifically this idea of disease of the mind. Okay, it was held that any disease which had led to an impairment of the mind would count as a disease of the mind for the purposes of insanity. Now, this is particularly interesting because disease of the mind seems to, at least colloquially, draw our attention to things that are limited to the mind. Okay, so something like maybe schizophrenia, or maybe something like depression from the previous case. Okay, these are mental illnesses. However, Lord Diplock seems to suggest that so long as a disease, or so long as a condition has an impairment of the mind, this could constitute a disease of the mind. So even theoretically, a physical disease or a physical condition, something like diabetes or something like that, could, if it has an impact and it has an effect on the mind, and an impairment on the mind, could constitute a disease of the mind for the purposes of insanity. It was also held that the duration of this impairment would be irrelevant to the consideration. So all of these things are actually very, very interesting and very, very important when it comes to understanding what is theoretically quite a broad definition of disease of the mind. Any condition which could lead to an impairment of the mind would therefore count as a disease of the mind. I would like to draw your attention now to the 1989 case of Crown versus Hennessy. This was a case in which the defendant had illegally driven a car without a license, and he had been in a state of hyperglycemia as the result of his condition, which is of course diabetes. Now, not only had he not taken his insulin, but he had also not eaten for a couple of days. Okay, and this is a very key consideration that we ought to think about as playing into this idea. All of this was also wrapped up in a spate of mental conditions caused by the diabetes, such as depression and stress. So there was a lot of things that were going on with this individual that needed to be untangled and torn apart and thought about in a more constructive way. Now, while the judge at the trial level directed the jury to acquit on the basis of levying the defense of insanity, to avoid the label of being considered insane, as was the case in the case of Crown versus Clark, the defendant decided to plead guilty instead. Notice here that even into the late 1980s, the stigmatism that exists around mental health and around being labeled as insane is so strong that people would rather plead guilty and take their punishment, take a criminal record, take whatever it is that is the sentencing, than actually be considered to be labelled insane and to have that defence. On appeal, the argument from the defendant was the more accurate defence of automatism. This was also dismissed. It was considered that the disease of the mind, which it was a disease of the mind which did impair mental faculties. And so what we notice here is that, like I said, and like noted in the case of Sullivan, disease of the mind does not necessarily and isn't necessarily limited to mental illness, isn't necessarily limited to something like something like a depression or an anxiety or an epilepsy or a schizophrenia. It could also be a physical illness, a physical condition such as diabetes, which is of course understood physically as, depending on which type diabetes, the regulation of insulin in your bloodstream or the lack of insulin in your bloodstream or blood sugar levels, all these different kinds of things, but that the physical condition has an impact on your mental state because it can send you into a state of hyperglycemia, which is of course which can lead to mental impairment. And so it was considered here that mental impairment is the key factor when it comes to determining what a disease of the mind actually is. It was considered that it was a disease of the mind because it's impaired on mental faculties of the defendant.